Okay. Now, do I have like 2 lives open? Oh my god. I don't know what it is. It's like. Okay, so the internet isn't working on this thing. Twice. Can I see myself in any of these? Okay, that one's that. I'm like even sharing my screen too. Oh, I can see myself on the other one. Okay. So let me try to end this stream so that I'm only on this new one. Okay, I can see myself in this one. Oh, Momo's thinking, hello, double I to now. Is this the new live? Yeah. All right, I think I figured it out now. Yes, this is the new live. This one's working, huh? Awesome. Okay, so I don't have as many features in this one as I do in StreamYard. So bear with me. This is, at least I was able to share the screen, right? Oh my god! That is so cool. All right, so I'm glad you guys can see it. All right, so here we are here. I see about 6 of them. So we'll start with this one. The state's response to the defendant's motion for leave to file additional expert witness disclosures. Welcome, everybody. Thank you for bearing with me while I get this together. Hi, Diane. Welcome. The other one is still up. Hi, Diane. Welcome. The other one is still up. Yeah, and blurry. Oh my gosh. I might have to just not do this one today. I'm so sorry, guys. This is so terrible. I can't. I don't know where the options are. Pop out dashboard. Uh-oh. Just read it to us, no problem. Miss Q, welcome. Oh, Miss Q will be gardening, but we'll pop in the chat every now and then. Steve W, welcome. All right. All right, so I was thinking I could fix the resolution in here. Hey, Meg P, welcome. Welcome, Jackie. This looks weird, doesn't it? Oh my gosh, is the resolution really that bad? So this is the state's response to the defendant's motion to leave. So this is the state's response to the to file additional expert witness disclosures. Comes now the state of Idaho by and through the Latah County prosecuting attorney, and in response to the defendant's motion for leave to file additional expert witness disclosures dated March 3rd, 2025, advises court and counsel that the state does not oppose the court granting leave for additional expert witness disclosures. Particularly in this case, discovery has been complicated, dynamic, and constantly evolving as new information comes to light. The state believes it serves the interests of the parties and the court for there be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. The state does, however, dispute the defendant's allegations regarding the state's lack of any real defendant's motion at page 2. As the extensive disclosure by the state, this allegation by the defendant is anything but accurate. Oh, this was a little angry there. Do you guys hear that from Bill Thompson? He's a little snarky. Typically unique, welcome. Truth and Justice with Anna D, welcome. Twizzlestick is lurking. Is he? Oh, I don't see him yet. Is he in here? He profile pic does. These docs scare me. Oh, Diane, you were able to look at them? Yikes. Did I miss anybody? I think I said hello to everybody in here. Meg P, welcome. Oh, hi, Preston B, welcome. Yeah. Yeah, Diane saw these already. Go to the next one. That one, I can feel the heat from Bill Thompson. He was a little upset. I mean, if I were Bill Thompson, I might be upset too because his case is falling apart. All right. So here's the next. This one is titled State's Response to Defendant's Motion in Limine Number 8 regarding the unnoticed 404B evidence. Comes now, the state of Idaho, by and through the Latah County prosecuting attorney. And in response to defendant's motion in limine number 8 regarding unnoticed 404B evidence filed on February 24, 2025, counsel that the state intends to comply with the application Idaho rules of evidence in regard to proposed IRE. Oh, that one just, I can just feel the heat off these. All right, let's go to the next one. This one is the state's motion or the state's response to defendant's motion in limine number 10 regarding improper expert opinion testimony, Middleton. All right, this one says, comes now the state of Idaho by and through the Latah County prosecuting attorney and response to the defendant's motion in limine regarding improper expert opinion, Middleman, filed on February 24, 2025, as follows. The state's disclosure regarding Dr. Middleman was in response to response and rebuttal to the defendant listing Leah Larkin and Daniel Hellwig as expert witnesses in regard to IgG matters and demonstrates his superior quantifications by education, research, and direct experience with the investigative genetic genealogy. However, the defendant has indicated that he will no longer seek to offer evidence related to the IgG. See defendant's February 24th, 2025, motion in limine number 11, exclude IgG evidence, including not for Mr. Hellwig. The state has no intention of calling Mr. Middleman to testify in rebuttal. The state notes that its February 25th, 2025 state motion in limine regarding IgG genetic genealogy, seeking, among other things, an order in limine describing to the extent genealogy used in this case is still pending. In light of the defendant's position that he will not be raising any issues related to the IgG evidence, the state agree and now gives notice to the court and counsel that it will only seek to introduce evidence testimony that law enforcement received a tip without mentioning of the source or substance of the tip, and that law enforcement then followed up and identified the defendant. See state's response to defendant's motion in limine number 11, exclude the evidence. Respectfully submitted, Bill Thompson. All right, let's go. Did I read this one already? Yeah. And Suzanne B., welcome. Truth and Justice with True Crime with Anna D. Anna says, well, if Mr. S is angry, he will be all right. He mad because they called him out. Oh, am I cutting in and out? Oh, no. Oh, that's so terrible. That's like everything. The internet is slow. I can't get onto StreamYard. This is sort of working. Okay, so this one is to exceed the page limit. Comes down, State of Idaho, buying through Latell County prosecuting attorney, and respectfully moves the court of the 4th Judicial District rule to exceed the page limit and eliminate number 11 regarding the state's response presented to the court clerk, along with the motion exceeds the 15-page limit by 1 page due primarily to the citations to various portions of transcripts, which the state has included in the motion as a summary. It's not that bad, Makepeace says. Okay. I'm sorry, guys. StreamYard is good when you have it, I suppose. All right, and then this last one is an order from Steve Hippler, and he's granting the motion for leave to exceed the page limit. It says, based upon the state's motion for permission to exceed page limit and good cause appearing, it is hereby ordered to the defendant's motion in limine. Now, so typically unique. You said it did it to you yesterday. So I feel like when Anne pulled, like she and was it one of her motions in limine where she's like, well, we're not going to call Leah Larkin or David Hellwig. And so is that like cutting the state's feet from under them? Because like their whole thing is they have to about that tip. Like they have to do everything they can so they can talk about it. And Anne did something that could have threatened that. And I don't know if are we feeling and seeing heat from Thompson? Yeah, so Diane says, I don't get the defense suddenly doesn't want to use the IGG. Well, I think it was a strategic move. I don't like there probably is a lot of things behind the scenes that we just don't know, like that is going on. And I think we know that the state's case is like a house of cards. Once Anne pulls the right card, it should all come crumbling down. And I wonder if this card that she just pulled really shook the state. Because the tip, they've talked about this tip. The tip is so important to them for some reason. The jury won't understand, Steve W. says. I agree with that. Makepeace says, I think they have to file as many motions as they can in a DP case. That's what I have been told. Yeah. Okay, well that sounds like that's very true. I think I've heard that as well. Anna D says, if the state doesn't present the IGG, what do they have? The bushy eyebrows, right? This is going to stay. If they're allowed to use, we identified him by bushy eyebrows. That's going to set like precedent. Not good. Not a good one either. Oh, Twiz is in here. Welcome, Twiz. Twiz says, some argue the most important part. Chanel says, railroad by the right? Makepeace says, yeah. Hi, Twiz Fireman Stick. Oh. Diane says, no, they will present the DNA. Yeah. I don't know. I felt some heat from that first one. Oh, and the second one where they're like, "Well, yeah, we plan to follow the 404 rule." Like, what are you talking about? It's like they're so sensitive. The first one is like, no, no, what the defense is saying is not true. I don't know. And I did see there's some worry about it that if the state can use the tip without any context around it, that could be problematic for both sides, I think. Momo's thinking says, if 911 call is emotionless, play it first. If I were AT, that's a really good idea. That is a great idea to get the jury early on to get an understanding of how that call went. That call is very strange. Tanel says state's entire case is backward. Definitely. Anna D says, so I found something that SG wrote and he talked about that one stop of BK in August. Oh, what did he say, Anna D? Twist says maybe that's why they had no neighbors call. Diane says, I think Ann heard it. Oh, the 911 call. So let's say that Ann did hear the 911 call. Like, I know that we know a lot of all this information because, we've been studying it and we've been, we have a whole YouTube out here of people doing all of the kinds of research that they do. So when there's a big body of work out here because there's so many of us and we all kind of dive into the research that, is either in our field or the kind that we like, or, for whatever reason, whatever you bring to the case, where Anne has, not only does she have a smaller team, but she also has to, stay within the legal system. And so even if she were going to argue that like the DNA was planted, that's very difficult to do in a law setting. Even though I think for me and for us out here, it makes complete sense, But like how well does that translate into the court? And like, will of all the IgG, except for, it's only a tip, how could that affect the argument that the DNA was planted? So I think even if the DNA was planted, technically that's still secondary trace DNA. So no matter how you slice it, there's an argument to be made for secondary trace. And if that's the overarching argument and that can include planting, then hopefully Anne continues the route for the secondary trace that home, because that is scientifically based. It's very difficult for attorneys and defense teams to prove any wrongdoing by the state or the law enforcement. It shouldn't be that difficult to prove, because the more and more I learn about the legal system, the more and more I learn that the police are breaking their guideline procedures, and they are not investigating properly, or they're getting away with things that I don't know. The majority of cases I've seen so far, there's innocent people that they've railroaded. And that definitely comes from a culture, like a work environment. So it's a systematic thing that's happening here. And within that systematic framework, it's such that it's nearly impossible to prove that law enforcement had any bad faith or they didn't quite follow the rules. When, if you're looking outside the lines of the legal system, it's pretty clear that some of these the law enforcement, they're definitely not playing by the rules. And You know, that calls a domino effect. In the system, it takes twice as long. You have to get processed in and processed out. So once you're in the system, it's not like you can just leave, or you can say, well, I'm innocent, prove me innocent, and walk out of court. It doesn't quite work like that, unfortunately. Oh, Meg P says, kind of ironic that BF and BK got pulled over the same day, allegedly. Yes. I mean, what are the odds of that happening? Oh, Backwood Beats, welcome and happy birthday. Everybody give a happy birthday to Backwood Beats. Backwood Beats says, these documents make more sense backward, where the text flipped on purpose to mislead. Was that Sherlock Rome's video? I wonder if I can put it in the chat. It was excellent. Excellent video. Yeah, if you read the text backwards, it makes a lot more sense, and it kind of has a better flow. It's almost like it's naturally supposed to be read backwards. Let me see if I can pull it up. Sherlock Holmes. Oh, I found him. All right. Was it his most recent one, or was it Sherlock Holmes? Who was, or was it you, Backwood Beats? Am I getting them wrong? I did watch that earlier today. Oh, it's not this one. Is it? I don't remember. Oh, I can read it backwards. That's a great idea. Echoes is here. Welcome, Echoes. Did I miss her? I didn't see her. Sorry. Well, welcome, Echoes of Clarity. Good to see you wherever you... Oh, there you are. I can see your words. Okay. BF to DM, down here. BF to DM, run. BF to DM, come to my room. DM to BF, my phone is going to die. But BF to DM, so am I. BF to DM to BF. I'm not kidding. I am so freaked to BF. Like he had something over his head and little and mouth. DM to BF. Like he had something over his forehead and little mouth. BF to DM. Actually, BF to DM. Shut the fuck up. DM to BF. No, it's like a ski mask almost. DM to BF. I'm freaking out right now. BF to DM. Santa was wearing all black. BF to DM. Yeah, what the fuck, dude? DM to Gonzalez. What's going on? DM Kaylee. DM to BF. I'm really confused. That is so clear. Did you guys hear it? Like, it has to be backwards. They definitely had to put them in there backwards because that just flew right easier that I read it that way. It makes more sense. Xana was wearing black that day. Yeah, that famous picture. Yeah, because it's like, down here, run, come to my room. My phone is going to die. So am I. I'm not kidding. I'm so freaked out. Like they had something on his head. Actually, no, it was almost a mask. I'm freaking out right now. Well, Xana was wearing all black. Yeah, what the F? What's going on? Kaylee, I'm really confused right now. No one is answering. That flows. And then I'll read it down the other way where it feels conjoined this way. No one is answering. I'm really confused. Kaylee, what's going on? Yeah, W2F. Santa was wearing black. I'm freaking out. No, it was a mask. Shut the fuck up. Actually, like something over his forehead. I'm not kidding. I'm so freaked out. So am I. My phone is going to die. F, come to my room. Run. Down here. Versus, down here. Run. Come to my room. My phone is going to die. So am I. I'm not kidding. I'm freaked out. He was wearing something over his forehead. Actually, shut the fuck up. No, it was like a ski mask. I'm freaking out right now. Santa was wearing all black. Yeah, dude. WTF. What's going on? Kaylee, I'm really confused. No one is answering. Feels like a lot. Tadell says it feels like a lot is missing when read forward, but flows when read backward. Yeah, I would agree. Thank you for bringing that up, Backward Beats. Backward Beats says, I've got a sneaky suspicion that in plus crew is up to something. Yes, okay, so Backward Beats, I would agree because, I mean, yeah, there's going to be a lot of things that are going on behind the scenes. Anyway, but I can feel it. Like in Bill Thompson's responses, he's not happy. Miss Potts, welcome. Who's driving? Everybody, be careful driving. Backwood Beat says, might be a problem now, but come trial time, I bet it'll be blasted into the ether like a bad courtroom drama twist. Yeah. Meg P asked Miss, doesn't it make more sense backwards? Yeah. That is so weird. Hi, Yvonne Poole. Welcome. Yeah. I saw Yvonne Poole and Backward Beats, and actually almost all of you have come over to the 24/7 live music stream to say hello. I'm just popping in and out of there, you know. Anytime I get a second to listen to music, I see someone in there and I say hi and then I pop out. Yeah. So, can you guys help me remember? Was it Sherlock Holmes who posted the video? Maybe it was a post on his page. Because I know oh my God, that totally sounds. Yes. Okay. Let's give Sherlock Holmes some credit here. This is the first I read it from. And it says here, can you see it? Sherlock Holmes posted it. Thank you, Meg P. Thank you, Diane, but I found it. Or thank you, Diane, I found it. No, all credit goes to Sherlock Holmes. Right, and if you guys aren't subscribed to Sherlock Holmes, subscribe to him. Diane has a new YouTube channel called To Die For, and Die is spelled really cute, D-I, like her nickname. So subscribe to her too. I can put both of their links in the description below. And Truth and Justice with Anna D has a great channel. Subscribe to her. And Miss Potts has also a very great channel. Lots of good information on there too. There's so many great creators in here right now. That's so amazing you guys are here. Yeah. Okay, so Sherlock Holmes posted this earlier, and I guess he got this information from Hayward You Hug Me. He says, Hayward, you hug me makes a good point. Do these texts make more sense backwards? Did Verizon extraction return the order reversed? Read from the bottom up, which we just did, and it flows very well. Okay, so this, where did it? Look, like my comment is right on top. That's so funny. Can I here? All right, so it looks like Hayward, you hug me. He posted. I can't see the whole thing. It's not letting me click, but it says maybe just realize that texts make way more sense when you invert them. Reading the bottom and work towards the top of the list. They could have scheduled those texts to go out. That's amazing that happened. Oh, thank you for putting that in the chat, Diane. Diane has put in Sherlock Robes' YouTube channel. Oh, Miss Potts says, I think no matter which way you read it, sounds like Dylan and Bethany heard Kaylee and Xana going at it, but that's just my opinion. Very interesting because they're mentioning two in that exchange. And they're mentioning them obviously for a reason. Obviously, we know that, because we are retrospectively looking at the situation. But when they're texting, it could either be real time or, afterward if they, let's say most likely it was in real time. So they're in real time and they're mentioning two names, which is significant. So yeah, I would say that there was something going on between Kaylee and Xana, whether it was directly between them or, something was going on with them. Definitely. So it got dark in here all of a sudden. Oh, my light isn't working. Heather Fitzgerald, welcome. So good to see you. Momo's Thinking says, my cats. Oh. Big P says, one of the comments on that post talks about Verizon and sending timed. So they could have plan or alibi for themselves. CIA activation. Heather Fitzgerald, what is the CIA activation? Diane says, I'm scared about what the jury will think. I do too. Miss Potts says, Dylan hearing Kaylee and the dog around the same time. Oh, yes. Wait a minute. What time? Well, let's see. What time was the last time when they said the car was speeding away? Was that like 4:23? And these messages start at 4:22. And so Kaylee playing with the dog would have been before 4:22. And then we have that 4:12. Was it 4:12 that Xana was on TikTok? Or was that when she received a DoorDash or something? All right. Oh, look, here's Hayward, you hug me. He commented on Sherlock Holmes' post, and he says, just to clarify, I think the order got reversed in by the extraction. I mean, if you have Verizon text service, you can schedule text to send out later on. In my opinion, he typed out the script we see in a string. So I'm saying Verizon F's everything up, and that arrived onto the opposing phones with the order inverted. Sweet irony, it's inverted. Okay, so do we know what carriers either Dylan or BF had? Okay, Diane says, and Miss Pat say, 410 Zana is, or 412 Zana is on TikTok, and Miss Pat says 412. Wait, 410. Where am I getting 410 from? And Zana types queen at 412 as well. Okay. Yes, very humorous, Heather. Miss Fox says, and then all hell appears to have broken loose by 420, and Dylan and Bethany appear to be under the impression that it's Kaylee and Santa. Diane says, we need the DoorDash and the dog barking for this timeline. Miss Potts says, Dylan was same as Kaylee. Heather relearned. Okay, Heather, you're so funny. Yeah. Gosh. So then at 424, DM calls Ethan. And then it says, DM and BF continue to text. Okay, so does that say, okay, now they're going to go into how they are continuing to text. DM to BF, I'm screwed. BF responds, yeah, I know, but it's better than being alone. DM calls Kaylee again at 427. And 428, DM calls Xana. 432, DM texts Kaylee, please answer. So why would DM say she's screwed though? Like, did DM pay a prank on them? And she was just like, she didn't realize, but she had a feeling of what happened, but she like didn't want to believe it, so she didn't call police or something. Okay, Miss Potts brings up another great point. DM is only calling Kaylee, Ethan, and Xana. And that goes to a little bit of what I was saying earlier, that Xana and Kaylee's names are brought up within the text. Like, they say their names. And then she does give Ethan a call, but there's silence from what we know between Dylan and Maddie, which is very weird because of that. There's that one photo, and then there's that, whose TikTok was it? Was it Maddie's TikTok? Them is being made fun of. And then there's that And Xana is there kind of with her arm around DM. And there were rumors that Maddie was bullying DM. Wow, Wakantanka. Well, Wakantanka says, I was listening to Kane's reverse track of Steve and Christy last night. Steve 5 times in like 30 seconds in reverse. Is that true? I don't know. Are there studies there that say when you reverse our speech, you can hear things coming through that's in our subconscious or something? I feel like I've heard that. I don't know if that's like a TV show or like there's real evidence out there that that can happen. There's just so much we don't know about this case. That so many times. Backwood Beat says T-Mobile works great unless you need real-time data. In that case, just ask a psychic. They'll get it faster. Yes, Miss Potts, it was Halloween. It looked like something was going on between the two. That is a great point you pick up, Miss Potts. It's like, well, a DM certainly was not concerned about Maddie. So, yes. So Heather Fitzgerald says that, yes, you can play things in reverse and you'll find the truth. Well, it looks like we're playing the text messages in reverse and it sounds a little better. So that it's working. You have to work the entire case backwards, or is it already? Oh, Heather has her magic 8-ball. That magic 8-ball gets a lot of work, guys. I don't know if you guys know that. Shall I consult it? Yes, please, Miss Heather Fitzgerald. Please consult the magic 8-ball. That would be great. So Wankin Tonka says, that's what they say. If you close your eyes and just casually listen, you will hear way more logical words. Logical words. CIA activated. So Heather Fitzgerald says at Keynes, we listen to a lot in reverse. Initiation is the most common word. Not even joking. Oh, Meg P asks, Heather Fitzgerald, your brothers ruined my magic 8-ball. Oh. Kate, welcome. Wait. She said, I'm so screwed. I didn't even think it could say scared, but it could. Juan Antaka says, since I've been accused of being a conspiracy theorist, I might as well play the part. Innocent. Lowercase arrow is right above the A. If you type the R after that already hit the A, then you get an uppercase R. And then if you hit next to it. Okay, so you do think that she actually scared. All right, that makes sense. Heather Fitzgerald says, the 8-ball says, my reply is no. Oh my gosh, Heather Fitzgerald, you're so funny. She says, Meg P, you're my mom. You just can't be innocent. All right. You guys are being really funny. Yeah, I want to know why I should check on Maddie. That's a little scary. Well, then up here it says Susanna, Kaylee, Maddie, DM attempts to call all answers. I don't know about that. Everything else looks like it. Maddie isn't even in here. Oh yeah, did you guys see this? I noticed this for the first time today. That the state lists, I guess that's Eric Gower as the Uber driver. We've been trying to find out who the Uber driver was. So look, it says here from 419 to 421, DM attempts to call BF, Zeta, Kaylee, and Maddie. That, I mean, at 419, wouldn't she have TikTok? I kept picturing Zana in the living room. I don't know. Of course, I have like my 3 favorite motions in Lemonade. And I thought about something the other day that I wanted to bring up. Oh yes, where were we, Heather? I think we were in Miss Potts's chat where we were both agreeing that this motion here, this motion lemonade number 5, the inconclusive data, where Jane Miller, in the grand jury testimony, Jane Miller testified as to the results of testing done on item Q13.1. No, it wasn't the. Oh no, it was this one. The use of misleading language confuses and misleads the fact finder. It is barred by the rules 402, 403, as well as due process in the evidence of overly prejudicial, the erroneous, irrelevant, and prejudicial evidence will offend due process when it renders trial fundamentally unfair. Here, expanding beyond the language of the report would prejudice Mr. Koberger in that it might allow the jury to inconclusive data would mean that he might be included. Different from traditional statistics that courts and juries are used to seeing and hearing. The likelihood ratio is a comparison of hypotheses. It is not a statement of identity or probability. So I think that goes directly to the 5.7 octillion. I thought that was a likelihood ratio, which means that's not identifying Brian at all. The ratio simply asks the question, given this data, which hypothesis test is more likely? So it's asking for a test that's more likely. So there's a test that's 5.37 octillion times more likely. There's not a DNA profile that's 5.37 times more likely. 5.73 more likely. And even here it says for 13.1, both hypotheses tested for each individual assumed that MM's DNA was present. This is a present with either Kaylee and an unknown person or Maddie and two unrelated persons. So Bicca-Barlow defines what likelihood ratio is, and that is the question of which test is more likely. And so the question is, MM's DNA is present. Is Kaylee's DNA unrelated people? And so then we got to look back at the 7 octillion number. That's a question of a test. So even if the defense does not contest the DNA as it being Brian's, we still don't know what the actual statistic is. That's never really been given to us. And I know, and Twiz always asks the best question. We still don't know how much of a match it is because 5.37 octillion is not that type. It's not a statistic for identity or the probability of identity. So the state released that statistic to the world, and it is very prejudicial and inaccurate about Brian's identity or the probability of the actual statistic for what would be considered a match. We still don't even know. Twiz, whose secret was that the real secret is to cheating? What is that? Oh, so you guys have been asking Grok to make pictures of Brian? I'm going to have to do that. I didn't know Grok was making it happen. Oh, my camera went out. Can you guys still see me? I can't see me. Oh, okay. Oh, my camera went out. I guess because it just didn't work. Oh, I think I could delete that. Okay. Wow, have I been on here for? Wow. Diane says I cracked Brian in a Haywa blouse fancy suit. Oh, that sounds so good. All right, what happened to my camera, guys? don't know. This is just so difficult today. A Hawaiian fancy suit day. I wanted to bring up the state's motion for protective order. When was that? Oh, it's not even on here. I know. Yeah, I went invisible, made Pete. Wakantaka says, grower has connections to Montana, Idaho, Washington, and Oregon. Really? I have the motion for protective order like saved on my phone because it's objections to states. Not that word. Because we can read the part about the octillion again, see if it makes if any more like dots can be connected. Reading the motion eliminate for the likelihood ratio from Bickle Barlow. And yeah, it's always one of it's one of my favorite documents is that. Well, so all right, let me see if I can pull that up for everybody. Can you guys see this one? So backward beat says you've got a brutal crime happening in the house, and instead of hearing chaos, there's casual texting. Then the 911 comes hours later reporting an unconscious person. If this was the bloodiest crime scenes ever, how does the 911 call just mention an unconscious person? With zero mention of blood, either there's some serious downplaying going on. If these were dudes, they wouldn't even get a good morning before getting cuffed and stuffed into the back of a squad car. 4 homicides. These cops would have had them say attorney. And even then, the cops would probably accidentally slam their heads into the squad car and say, you can lawyer up later. First, start explaining. Okay. So here, I'm going to do the octillion. Here you go. So it says, a traditional STR comparison was done between the STR profile found on the K-bar sheet. And the comparison showed a statistical match. Specifically, the STR profile is at least 5.37 octillions time more likely to be seen if the defendant was the source if unrelated individually randomly selected from the general population is the source. That sounds like a question. Sound like the likelihood ratio. So is this even accurate? This 5.37? And the state put it in here knowing that it was disseminated on the mainstream. And they know that when he hears the word DNA, that the jury is most likely going to. So that is so terrible that they put that out there, and we don't even know what the match actually is. We don't know the specifics. Or is there even a match? Like, they're just talking about the likelihood ratio. Like, that, it bothers me that they would purposely mislead. So, unless you're a golden child, good luck, because that runs covers up like it's a full-time job. And good luck, they get a hand-capped perk, says Backwood Beats. So, Backwood Beats, did you plug in the 911 call and text into AI? What happened? All right, I want to look up. It's also unclear in state's protective order if it sounds like the likelihood ratio, but then they added the word random person, which could also be this random probability. And I'm wondering if, is this the statistic for the rarity of a DM profile? Oh, I have read this so many times. Okay, look, so I really do believe that, well, was it Becca Barlow who said that the DNA that they're talking about is the prosecutor's fallacy that was in her declaration? And here it talks about two widely recognized fallacies. The prosecutor's fallacy, also the fallacy of the transposed conditional. It is to confuse two conditional probabilities. Let P equal the probability of a match given the evidence genotype. Then the fallacy is to say that P is also the probability that the DNA came from someone other than the defendant. A likelihood ratio of 1,000 says that the match is 1,000 times as probable if the evidence and the that share the same profile are from the same person. As it is if the samples are from the same persons. It does not say that the odds that the DNA evidence are 1,000 to 1. 7 million, I do believe, is the likelihood ratio. So that statistic that the suspect contributed the evidence, DNA. To obtain a probability requires a a Bayes theorem, and a prior probability that is assumed or estimated on the basis of non-DNA is 1/2. Will the posterior odds equal the likelihood ratio? So was Brian actually identified by a DNA database? Like, because here it says suspect identified. Thus far, we have assumed that in this case, such as testimony of an eyewitness or circumstantial evidence. In the case, the DNA is tested and the match probability or likelihood ratio is computed. For the event that a person selected at random from some population will have the genotype profile of the evidence sample. There is an important difference between that situation and one in which the suspect is. In the latter case, the calculation match probability or likelihood ratio should take into account the search process. As the number and size of DNA databanks increase, the identification of suspects by this means will become common. Already, more than 20 suspects have been identified by searches through databases. I'm sure it's a lot more than that, maintained by various states. The number and sizes of these databases are sure to increase. The logical difference between the two situations described above, observe 20 reputedly unbiased coins. There is roughly 1 chance in a million. All 20 will show heads. According to standard statistical logic, the occurrence of this highly unlikely event would be regarded as evidence discrediting the hypothesis that the coins are unbiased. But if we repeat the limit of 20 tosses a large enough number of times, there will be a high probability that all 20 coins will show heads in at least one experiment. In that case, an event of 20 heads would not be unusual and would not itself that the coins are biased. The initial identification of the DNA database is analogous to performing the coin toss experiment. A match by chance alone is more likely the larger number of profiles examined. Oh, that's interesting right there. There are different ways to take the search process into account. The 1992 NRC report recommends that the markers used to evaluate a match probability be different from those used to identify a suspect initially. In that case, the database search is much like identifying the suspect from a non-DNA evidence, and the methods of Chapter 4 apply. However, the procedure might be difficult to implement. To avoid identifying several suspects who would be investigated, one might need to use a large number of search. Then, according to that procedure, those markers could not also be used in further analysis. If the amount of DNA in the evidence sample is too small, following the recommendation in the 1992 report could leave too few for computing a match. A correction to the account for the database search can be made in computing the match probability. Let M denote the event, the ith DNA profile matches the evidence sample. To decide if the database search itself has contributed to obtaining a match, much as the repeated example given above, an event that at least one of the database profile matches the evidence sample. Suppose that we hypothesize that the evidence sample was not left by someone whose DNA profile is in the database, or a close relative of such a person, and find that under this hypothesis, P, M is small. The usual statistical logic then leads to rejection of the hypothesis in favor of the alternative. One of the matching profiles in the database comes from the person who left the evidence sample. Under these hypotheses that the person leaving the evidence sample is not represented in the database of n persons, a simple upper bound of m is given. You know what I just thought? So, has law enforcement and investigations become, well, I bet the person's DNA is in it. So it's not actually a person giving a tip. They're just putting things that they find at the scene or wherever and let a database, like a slot machine, find a lucky winner. And then they're saying, oh, it was just a tip because a database found it. Is this the extent of investigations now? That's it. That's what they the database. They let the database solve the crime, and then they have situations because it's pretty clear they didn't investigate. Even Ann Taylor has said that this false fake investigation because a database found a DNA match, allegedly. So does that mean that the prosecution has to be able to say they got a tip, aka we got a tip from a DNA database? So they're going to leave out the part where the tip was from a DNA database, but they're just going to say it was a tip. And they even say we don't have to, like in that the movie we just read earlier, they're like, we don't have to say where it's from, we just have to say we have a tip. That's because they have to say they have a tip or it wasn't found anywhere. Like, their whole investigation is from a DNA. There's nothing else. And so to be able to bring it into court, they have to be able to stand on something. So they have to be able to tell the court they have a tip without saying where it was from. Like they have to do it. I mean, is our legal system equipped to say the defendant and the case was solved by a DNA database? That's it. The legal system is much more robust than that. And usually there's a lot of things that go into presenting a case. A lot of ways where you have to follow the procedure process. That requires a lot of information so that the trial can go on. But what if you don't have any of that information? You just have a tip from a DNA database. You're not going to have all the information you need, to be filtered and flow through the legal system. And so how are the states continue to use our legal system without putting in the necessary information to be able to? That's it. I don't to be able to absorb that there was only one thing done, which was to get output from a DNA database. Like, the system is created so it can have a robust investigation, so it can absorb all the information that had happened for the purposes of due process, for a fair trial. It's fair for the defendant to have that information to be able to defend themselves. Like, that is the foundation of this information. How is that even fair? How is this even happening if they literally have one thing? It usually is like, they have lists of in the investigation. They have lists of like what they found. They have lists of some probably of the decision making and the outcomes of those decisions, and everything is documented to be able to put in, where they might have like what, a printout. Like, yeah, we found the database found this. I don't know. Is our legal system even equipped to do that? Twiz, you bring up a great point. Finishing partial or not quite a full DNA profile, AI is not finishing that. AI is probably also running different searches throughout all the DNA databanks. So AI is being utilized to basically create these DNA profiles, because that's work them up or they bootstrap them. So they're filling in blanks, and now they're just having an AI fill in the blank. Oh, typically Unique is back. Hello. Well, I initially came over here to read about the random match, but let me finish. I just had a thought. I got off track. So the equality in equation 5.3 holds that if the database is homogeneous, that is, if P same for all profiles in the database. 5.3 motivates the simple rules of the match probability searched, or that part of the database males in a search for a match sample. Suppose that PM is equal to 10 and N is equal to 1,000. Then PM must be 0.00. In a computerized database search, the computer output ordinarily lists all profiles of the database that match the evidence sample profile. It is also possible to search profiles one by one in one or more databases until one or more matches are obtained. If that procedure is followed, the appropriate database for computing the match probability is the complete set of profiles that are compared with the evidence sample. Other situations be so simple. Databases. All right, let's see what this says. It says determining a match. According to standard procedure, a match is declared in two stages. Usually, the bands and the two lanes to be compared will be very similar positions or in clearly different positions. If they appear to the analyst to be in similar positions, a visual match is declared. So what kind of bands? The alleles of how they would be in similar positions or similar peak height can be declared and must then be confirmed by measurement. Otherwise, the result of the test is declared to either be an quality might result in an conclusive test. The visual match is a preliminary screen to eliminate obvious mismatches from further study. It includes some autores that might be passed through the measurement criterion as matches if the analyst took into account. No, I'm thinking that there might be less and less manual comparisons because their DNA database and the probabilistic algorithms that are run probably doesn't all for them. They're little anymore. It's just the DNA database of what it can, the input and output. That's it. There's your case. The measurement confirms that in the above procedure is based on the size of the band. Okay. I wanted to find the random match probability. There we go. So, database searches. If the suspect is identified through a DNA database search, the interpretation of the match probability and likelihood ratio given in Chapter 4 should be modified. All right, so recommendation 5.1. When by a search of databases, the random match probability n, the number of persons in the database. If one wishes to describe the impact of the DNA evidence under the hypothesis that the source of the evidence sample is someone in the database, then the likelihood ratio should be divided by n. As the database searches become more extensive, another problem may arise. If the database searched includes a large portion of the population, the analysis must take this into account. In the extreme case, the search of the whole should, of course, provide a definitive answer. All right. All right. Suppose a DNA sample from a crime scene and one from a suspect are compared, and the two profiles match at every locus tested. Either the suspect left the DNA or someone else did. We want to evaluate the probability of finding this profile in the someone else case. That person is assumed to be a random member of the population of possible suspects. So we calculate the frequency of the profile in the most relevant population or populations. The frequency can be called the random match probability, and it can be regarded as an estimate of the answer to the question. Here it is. All right, so the likelihood ratio and the random match probability are questions. And so the frequency can be called the random match probability, and it can be regarded as an estimate of the answer to the question. What is the probability that a person other than the suspect, randomly selected from the population, would have this profile? The smaller the probability, the greater the likelihood that the two DNA samples came from the same person. Alternatively stated, if the probability is very small, we can say that either the two samples came from the same person or very unlikely coincidence has occurred. There we go. So the state has never actually told us any probability of identity. They've never provided us with identity. And they put it in there purposely so people would think the 5.37 octillion is related to identity, and it's not. An alternative to calculate the likelihood ratio, a measure of strength of the evidence regarding the hypothesis that the two profiles came from the same source. Suppose we find that the profiles of the person contributing the evidence DNA is E, and of the suspect S were both X. We consider two hypotheses. The source of the evidence and the suspect are the same person. The source of the evidence is a randomly selected person unrelated to the suspect. Although there are other possible hypotheses, it is usually sufficient to only these two. The likelihood when that the suspect profile and the evidence sample profile will both be X, divided by the corresponding probability under hypothesis 2. The greater the likelihood ratio, the stronger the evidence in favor of the hypothesis corresponding to the numerator that the source of the evidence sample DNA and the suspect are the same person. Those sneaky prosecution, they did that on purpose and they knew what they were doing. That 5.7 octillion statistic is dubious because it is not about identity. What do you guys think? That their statistic is misleading, and the 5.37 octillion, it's not a thing. They asked a question to themselves and they labeled it that number. That has nothing to do with the identity of Brian Koberger. Like the actual probability of the DNA profiles matching. Tanel says we need a full report on the process they used, who did it, and if they had any bias, and how they extrapolated their results. I 100% agree. And I would hope that the state would want to give that over, because it's like, look, we did good work. This is what we found, and we're confident in it. But it sounds it's like anything but that. Oh, welcome, Don. Did I miss anybody else? Don says, defense. I called Grok to the stand. If Grok did Brian Kober commit this atrocity? They're gonna. I guess. Yeah. I'm sure most of us knew the 5.37 octillion durable anyway. We have our proof. Oh, right. I agree with you. Tanel, they say the tech is only supposed to help a solid case, not make a solid case. That wonderfully said, beautifully said. I'm going to repeat that because you said this very, very well. You should quote that or make stickers or something because it's beautiful. It's only supposed to help a solid case, It's not make. So true. Well said. Yep. Oh, I want to read what this bias theory theorem is. So this might have something to do with it. Here it says the Bayes theorem, the bias, I don't know how to, the likelihood ratio and the match probability being reciprocals contain the same information. The likelihood ratio, however, has a property that makes it especially useful, provided that prior odds are hypothesis that the two DNA profiles have the same source. Prior odds are the odds that the two DNA samples came from the same person on the basis of information rather than the DNA. Prior odds are the odds that the DNA samples came from the same person on the basis of information other than DNA. See, they're calculating stuff on information, not the actual DNA stuff. And the state absolutely poisoned the jury pool with us making a statement like 5.37 octillion. That's terrible. And our judicial, that I think could impede Brian's right to due process for that alone. And like they're just allowing it. So then what is our judicial system for if it's going to allow things like that? That's terrible. My gosh. Prior DNA information is included in the analysis. Stated this way, the posterior odds are the prior odds multiplied by the likelihood ratio. In everyday words, here we go. Listen up, guys. We're going to do it in everyday words. Whatever are the odds that the two samples came from the same person in the absence of DNA evidence? The odds when the DNA evidence is included are likelihood ratio times greater. The statement is that statement is an instance of Bayes' theorem. If there is reason, the prior odds that the two DNA samples came from the same person, however this is determined, are 1 to 2, and the likelihood ratio is 1,000. The posterior odds are 5,000 to 1. Many statisticians and forensic scientists prefer to use the likelihood ratio rather than the probability because it admits inferential interpretation that the sample match probability does not, they should not use that in the legal system at all. It does not translate to the regular person. The regular person just wants to hear the actual number. They don't want to hear any of these theories, and then it confuses things. This should be outlawed. This is terrible. Because it admits the inferential interpretation by the relation prob equals odds divided by odds plus 1, or odds equals prob divided by 1 prob. Likelihood ratio, which is not a probability, can be used to obtain a paternity. The relation between the posterior and prior odds is routinely used in paternity analysis. If the putative father is not excluded, enzyme and DNA evidence, a paternity index is calculated. The paternity index is a likelihood ratio. The probability of the mother-child-father profile combination, infinitive father, is the true father divided by the probability of this combination if a randomly selected man is the father. Customarily, the calculations make use of a database, and databases appropriate to the races of the person. The database is appropriate to the races of the persons involved. The prior odds are 1-to-1. That is, if the putative father is assumed to be likely to be and not be father. The posterior odds are suppose that the paternity is calculated to be 1,000. If the prior odds from the evidence other than that from DNA father. All right. So, with the high likelihood ratios typically found when DNA markers are used and the putative not been excluded, a wide range of prior probabilities makes little difference. In our example, where the paternity index is 1,000 possibilities for these 3 possibilities. Okay. So the bias theorem in criminal cases. What we would like to know and could most easily interpret is the probability that the suspect contributed the DNA to the evidence sample. To find that probability, we need to use a prior probability and bias theorem. Despite the regular use of bias theorem in genetic counseling and in paternity testing, it has been only rarely used in criminal cases in the United States. The main difficulty is probably an unwillingness of the courts to ask juries to assign odds to the basis of non-DNA evidence. It is difficult, even for experts, to express complex non-scientific evidence in terms of quantitative odds, and some commenters have regarded assigning prior odds to the probability that the evidence in the suspect DNA came from the same person as a violation of the presumption of innocence. I would absolutely agree with that. Some commenters have to the probability that the evidence and the suspect DNA violation of the presumption of innocence. However, the prior odds within a range are not important to a decision. With a 4 or 5 locus match, whether the prior odds are 1-to-20 or 20-to-1 will usually have no important effect on the posterior probability. If the likelihood ratio is 100 million divided by 20 is not the procedure of presenting posterior probabilities for a range of assumed prior probabilities has found favor among some legal scholars. Various approaches for use in the courts are discussed chapter 6. Okay, so there are 2 additional reasons for presenting posterior probabilities corresponding to a range of priors. Prior probability might be used with the bias. Bias theorem will probably be used by jurors, not an expert witness or an officer of the court. A prior probability might reflect subjective assessments of evidence presented. Such assessments would presumably be done separately by each juror in light of the juror's jurors. It might be confusing for a juror to hear prior odds assigned to one expert, then hear a likelihood ratio from that expert or another, followed by a more information to a jury in the order most easily incorporated into the Bayesian probability. For all those reasons, we believe it best if Bayes' theorem is used to present posterior probabilities or odds for a range of priors. How in the world do we get all this likelihood stuff thrown out, being able to use any of it? All it is just non-DNA evidence. So that would mean the 5.37 octillion is non-DNA evidence. But they're using it as DNA evidence. What is wrong with our legal system? There's something really wrong with it. Tanel says, if you can prove he was there, I can more than likely rule him into a DNA profile as a relative. Tanel says, I don't even think it's his DNA. I think there wasn't enough to build a complete house. They filled in common markers. I would agree with you. Beat says, Brian never being there, but his DNA magically showing up. That is like dropping a pin on a map and claiming you've been on vacation there. I don't even think his DNA. Oh, I read that one. Backwood says, oh, they've got stacks of paperwork, everything they think is important. Guess those were, oops, we forgot list, right? Oh gosh. It just says my internet was almost went out. It may have gone out. Did it go out? Backwood Beat says if that DNA was really Brian's, they'd have receipts for days proving it, right? But where's all the paperwork? And while we're at it, where's the chain of custody for the knife sheath? Did it take a vacay? Sounds like it did. Diane says that's why it's weird to see the new docs not including IgG. Well, guys, we've been on here for about 2 hours. I think it was a great stream, even though I had lots of technical disappointments, difficulties as well. Thank you, everybody, for being here in live chat. Thank you, everybody on the replay crew. I liked this one, even though we had hit some bumps in the road. I got lots of clarity on the likelihood ratio and how that 5.37 octillion is based on non-DNA evidence. Incredible, right? The things that we could. That's why we stick together.